Okay, so thank you. This is the International Choice of Law and Trademark Disputes, and it's my understanding that at the end of this panel, which is quite a short panel, as you can see, the previous panel and our keynote speaker will come down for a combined Q&A session. So before I briefly introduce our speaker, I was even interested in the title, International Choice of Law, and noted Graham's comment this morning that he was using the word internationally to have multiple meanings, not necessarily multilateral. And of course, in the choice of law context, that is very much the case, where it's essentially a national doctrine, despite some attempts and much discussion generated by many people in this room to have some international coordination. It also occurred to me that as Graham was speaking, he mentioned that it may sometimes not be satisfactory, and I paraphrase, to design trademark law based on the dominant role of one or two litigants, and equally so we can ask ourselves perhaps about choice of law as to whether to choose a choice of law rule results in perhaps favouring one sort of industry over another. So to the extent that some of the problems that we had through the discussion in the earlier panel can also be reflected in choice of law, perhaps we'll try and bring that together. Our speaker tells me that he has a controversial view on choice of law rules, which is good because I actually think all views on choice of law rules are in fact controversial because there's no agreement on it whatsoever, and therefore it makes a great topic for us to bring some of this together. So without further ado, let me introduce Edouard Treppoz, who is the director of the Institute of Art and Cultural Law at the University of Lyon and is here at Columbia Law School this year as a visiting professor. Edouard.
Thanks a lot, Susy, and thanks a lot to Jane and to the Kernochan Center to offer me the opportunity to speak on international choice of law in trademark dispute. Thanks also to Graham not to talk about choice of law issues, and to Annette to make a remarkable introduction on the subject. But the subject is not only contributory infringement, it also more generally international choice of law in trademark dispute. So if a controversy will arrive, it would be more at the end, and I hope it won't be a controversy. International choice of law in trademark dispute reveals a well-known tension between law and economics. From an economic perspective, one sees science exploited sometimes on a worldwide scale and valued on a global market. Nevertheless, from a legal perspective, things change radically. There is no more one side. There are many trademarks given on a local basis for local protection, each independent of each other. Whereas the market becomes global, the legal protection remains local. This tension increases with the Internet. First, the universal access offered by the technique seems to blur the relevance of a territorial approach, and then increasing the global economic view. Second, the Internet has made possible the creation of companies as global as powerful, and we have mentioned those companies. And those companies use and benefit of the universality of the technique to offer a single service available all over the world. So from this point of view, the local protection of trademark seems parochial, and at the utmost, a shift from a local to an international protection would be required. Advocated in a brilliant way, such a shift will be awaited for a long time. Because intellectual property law, and especially trademark law, are seen as a way, and still seen as a way, to regulate a market. Then, such a regulation has to be local, undermining any endeavor in favor of a real international substantial protection. The scope of the protection is somehow related to the scope of the market regulated by the law. It was the creation of a European single market that allowed the creation of a uniform European trademark. So at an international level, such a creation seems still a faraway dream. Does it mean that territoriality should and will govern trademark dispute for a long time? Not necessarily. Between locals and a real international protection, some intermediary solution may exist. And the tool is no more to harmonize substantive law, but to work with private international law, including choice of law and jurisdiction. And remarkable works from both sides of the Atlantic Ocean, the Ally principle and the Click principle, both particularly well represented today, show how to overtake a too territorial approach view and how to correctly handle the internet stake. National or regional approaches should integrate those ways of improvement in order to reduce the gap between economic and law. So after a brief presentation of those territorial approaches endorsed by European law but also by American law, I will try to find a way of improvement regarding those principles. So current solution. If technically, and Graham spoke about the International Convention, and more specifically the Paris Convention, does not impose a strict territorial choice of law rule. They nevertheless clearly lean toward a territorial view, explaining that such a view was adopted in Europe and in US. And the foster of internet has not yet changed the approach. In Europe, the territorial approach is clearly encompassed at both levels, jurisdiction and choice of law. As to jurisdiction, the recast of the Brussels regulation, which is our law for uniform law for jurisdiction and recognition of decision, the recast has extended the exclusive jurisdiction of the judge of the title to issue related to validity raised as a defense. And by this rule, the recast enact the controversy case GATT, dictating on a practical point of view a fragmentation of the actions. Because the alleged infringer, by raising the validity as defense, will impose to the owner of the trademarks to seize each judge of each title, excluding any consolidation as to jurisdiction. So you have an infringement all over Europe, and you have to sue in each country in Europe because the alleged infringer may raise as a defense the question related to the validity of the title. And such a fragmentation is extended at a choice of law level by the Article 8 of the Rome II regulation. Under this article, the applicable law is the law of the country for which the protection is claimed. But there is no possibility to choose the law applicable to use any party autonomy, which is allowed in Rome II regulation, and there is very few ways to use the law of the most closely connected. So there is no exception to this very territorial approach. The combined effect of those two rules imposes in each forum the application of the forum law. So it's a kind of double fragmentation at a choice of law level, at a jurisdiction level. US law seems at first sight, and from my European perspective, less territorial, whereas the scope of copyright or patent law is clearly territorial. The Supreme Court recognized in the case Bulové that the Lanham Act may possess an extraterritorial scope under certain conditions. But nevertheless, this potential extraterritorial scope, the outcome under US law seems the same than under European law. The owner of the trademark has to adjudicate in US for US infringement and not for infringement committed abroad. Such an approach is clearly endorsed by the famous Vanity Fair case about a trademark infringement occurred both in Canada and in US. The court refused to apply Lanham Act on an extraterritorial basis, explaining that it does not fulfill the exceptional set of circumstances defined by the Supreme Court in the Dulové case. It means that for the sales in Canada, the US Lanham Act may not be applicable. As to the choice of law, even if the method is not the same as in Europe, because it's more a unilateral method, the result is the same fragmentation of the applicable law. But furthermore, the court recognized that the crucial issue was the validity of the title. And because it was the crucial issue, the US court should decline jurisdiction over the claim under Canadian law. So we have the same double fragmentation, requiring suing in one jurisdiction for the infringement occurred in that jurisdiction. And so you have to face many infringements in many jurisdictions. You will have to sue in all those jurisdictions. With the internet, those territorial approaches seem weakened. First, the determination of the place of infringement appears like attempting the impossible. A cyber infringement at first sight, because being on the net, ignoring any boundaries, seems difficult to locate in one country. If difficult, the problem is nevertheless far from being impossible. A French scholar said about international contract that international contract having relationship with a lot of countries fly in a nirvana of contract. But flying in a nirvana of contract, we were able to attach international contract to one country by selecting a specific choice of law, a specific connecting factor. And as to cyber infringement, if it is clearly a vexing question, it is not a new question. A quite ancient scholar, 300 years ago, Johann de Vaux, raised exactly the same question with an archer launching his arrow from one point in France, and the arrow arrived in Spain. And he said, what should be the law applicable? What should be the lex loci delicti? So it's exactly the same issue we have to face now with internet. And we have to select a relevant connecting factor. As to choice of law, and at least that European case law teach us that the place of emission, the place of the beginning, might not be a relevant connecting factor, preferring the place of reception. But saying this does not end the story. We have to choose between criterion of visibility, a technical criterion, or accessibility, or criterion of targeting. From both sides of the ocean, in US and in Europe, the target criterion won, at least for choice of law. It means that Japanese law will not be applicable if the website does not target the Japanese market, regardless of the accessibility of the website in Japan. So you will reduce by the target criterion the number of laws applicable. It remains that for those acting on the internet on a global scale, they have to respect as many laws as local markets they target. And criticism strengthened when the issue faced an alleged contributory infringer. Because under European law and under the Rome II regulation, the law applicable to the main infringement is applicable to the determination of persons who may be held liable for acts performed by them. It means the determination of the contributory infringement will be governed by the law applicable to the main infringement. And from my understanding of the American case law with the case Yandex, it seems to be quite the same. So there is a dependence between the law applicable to the main infringement and the law applicable to the secondary infringement. And some wrote that it was a kind of hostage. Such a fragmented approach has been rightfully criticized as excluding any predictable solution and especially for service providers acting on a global scale and thus facing the risk to be deemed liable under an unpredictable law. This fragmented approach was seen as an illegitimate break to the technique by nature universal and to those using the technique on a universal scale. So, what kind of improvement could we find, and how could we overtake territoriality to improve our choice of law solution? Scholars and academic works, and especially Eli and CLIP principle, have drawn the way of improvement by using the private international law in order to overtake territoriality. The first way for which a consensus exists, at least among scholars, because European law has not endorsed this way, is supposed to consolidate action adjudicated in one forum under one single law. As to jurisdiction, the instrument of consolidation is known and requires to limit the exclusivity of the judge of the title to issues raised by way of an action. So an infringement action will not be related to the exclusivity of the judge of the title, and you may adjudicate at the place of the domicile of the defendant, having this way a general jurisdiction. But here consolidation ends at jurisdiction, and we have to find also consolidation for choice of law. We need one forum for a cyber infringement and one single law. And here also a way exists to offer consolidation, and this way is supposed to shift from the application to all laws of protection to one law, the most closely connected. And both CLIPS and Lyon principle share this will of consolidation by applying one single law for those ubiquitous infringements. We have a consensus, but modalities between CLIP and Lyon principle are not exactly the same. For the CLIP principle, it will be related to the use of a ubiquitous media, such as the internet, whereas for the Lyon principle, it is related to the characterization of the infringement who has to be ubiquitous. And another difference holds on the relevant factor taken into account to determine the law having the closest connection, while the CLIP principles give great importance to the infringer in order to offer him predictability. The Lyon principles are more focused on the relationship between the parties, offering perhaps a more balanced approach of the closest connection. But those discrepancies are not very important. What is important is to show and to underscore that consolidation might be possible and that we may have one single judge applying one single law for a cyber infringement and then overtaking the principle of territoriality. Nevertheless, one question remains as to the last way, the dependence of the contributory infringement to the main infringement. Should legislator go further, breaking this dependence? The answer is positive for the CLIP principle, whereas the Lyon principle maintains such dependence. My strong feeling is that such dependence should be maintained for technical and policy reasons. We have seen this morning, and the comparative session was very interesting, we have seen how delicate is it to draw the line between contributory infringement and direct infringement. In domestic law, it's a very tricky line, a very tricky boundary, and in comparative law, it's much more complicated. If we have one choice of law for contributory infringement, this line becomes a primary characterization, and has becoming a primary characterization under European private international law. The law applicable to this characterization will be the law of the judge chosen, the forum law. And it's very easy to do forum shopping in order to choose the law applicable to the characterization. And the Picnic case, recognizing the accessibility criterion, show how it is easy. This is the first technical criticism. The second criticism is at the age of technique and policies. My strong belief is that choice of law rule should encompass the structure, the policy of domestic rules. Choice of law rule in a certain way mirror domestic law. And I think in IP, in intellectual property, there is still a strong dependence between contributory infringement and main infringement. And so the choice of law rule should also encompass this dependence. There is no way to break the mirror between choice of law, between domestic law and choice of law. And finally, from a strict point of view, a strict policy point of view, a specific choice of law rule would, from my point of view, overweight the balance in favor of freedom of trade and against intellectual property law by allowing service provider to choose the applicable law by choosing the place of their location. And I don't really know why we should offer such a gift to internet service provider. And above all, the rules seem first not required to offer predictability as to trademark dispute. And second, the rule seems not large enough to assure predictability for intermediaries. So why the rule is not necessary for IP dispute? Because I think we could have one single law applicable by applying the law of the most closely connecting, the law the most closely connected. So as for IP dispute, predictability might be possible and might be possible at the main infringement. So we do not need a specific choice of law rule. And second point, the rule is not enough because intermediaries may be liable for IP, but also for hate speech, but also for libel, for all kind of tort. So if they need some predictability, they need predictability for all these secondary liability. So the choice of law for intermediary should go beyond IP, largely beyond IP, in order to offer them predictability. And beyond IP, from my point of view, it's really too much. And such a search would overweight freedom of trade, undermining not only IP issues, but also the local respect of local incrimination. And this is perhaps my French perspective, but the French local prohibition of hate speech should still be locally enforced against any intermediaries, regardless of the search of predictability for those intermediaries. And so we should not offer predictability to intermediaries, and by offering predictability, ignoring local incrimination who have to be applicable on a local way, only on a local way. So it seems that the search of predictability beyond IP for intermediaries would conduct to excessive outcome. And on the other hand, such a search, if limited to IP, does not require to enact a specific choice of the rule. It is why the dependence seems a better solution, provided that consolidation will be retained at both jurisdiction and choice of law level. If we have consolidation, we do not need, from my point of view, to break the dependence. And such an improvement will overtake a strict territorial approach, bridging law and economics.
can I invite the previous panelists and also our keynote speaker, Graham, to come forward for Q&A, which I'm sure there is plenty. So, please, questions, and then we will have responses. Yes, in the middle here.
Good morning. My question was inspired by Professor Kernochan's presentation, but it might be applicable for other panelists as well. I'm struck by the degree to which the focus of trademarks intensive seems to be directed towards either internet service providers or search engines. And I'm curious to hear the panel's take on something like ICANN's role in creating a closer scrutiny of domain registration limitations. In other words, if there's a clearly hidden bad faith actor that's repeatedly put out trademark or infringing works, why are we bothering with the Googles of the world and not just going straight to the network solution of up and down, and into the up and down? It seems like to me that could say, in the degree to which we can agree on the rules by which, say, ICANN would apply those judicial decisions to say that this is a bad faith actor and they shouldn't be found anywhere on the internet.
Yep.
Another just a second. Please, everybody, if you ask questions, just turn on the mic so we can take it in the recording.
Hear it?
No, I think it was audible. So.
Well, the question was whether there's so much talking about, well, Google on the one hand and eBay, if I may just use these two terms, while we're not talking about registrars that might register a lot of domain names that are obviously just misleading or at least not belonging to the right holders. Well, of course, the legal rules apply would be exactly the same. It's just that there is no actual litigation about that. Not in Germany, at least, and I don't think that in any other European country there is a lot of litigation. There has been litigation in the beginning of domain name registration, when the domain name topic was still very hot. It doesn't seem to be so hot nowadays because there are a lot of. This may go to Graham's point that there are sort of soft law. Well, it's not really soft law. It's these fora that deal with domain name grabbing. In Germany, we do it in the courts, but we do it in a very quick manner. So people are no longer so very interested about these things. In the beginning, there has been litigation, and it was actually found in a very clear way that the registrars really are not in a position to screen. They are just what they're doing is simply administrative services. They don't require any information, and the way in which the model, at least in Germany, the registration.de was built up was just mass registration, just first come first served. There was no interference of the person registering, or no looking into the domain names that were registered, and the courts found that was okay. So that was the end of the story.
Does anyone else want to add?
Just if I can push.
Yeah, your ability to respond is dependent on your technological skills, but let me pass you this.
or my pulse, apparently. I just two thoughts. One is, I think Annette's right that in terms of... All right, I know it worked. Sorry. Two thoughts. One is, I think Annette's quite right that in terms of transaction costs, the automation of the process allowed it to be very low cost, and that enhanced the fees of the registering a domain name, which enhanced the ability to have a presence on the internet, which has a whole bunch of knock-on effects, and that's part of the equation. The other thing in terms of ICANN's prior and other roles, where it has had a role in terms of articulating UDRP, it has to be borne in mind that in that context, quite intentionally, the type of dispute that was encompassed by that type of global rule was a narrow dispute on which basically the whole world agreed there was bad faith activity that should be restrained. And beyond that, in trademark disputes where you would have a disagreement, for example, as to who was potentially liable. So in Europe we have more potential liability, for example, for advertisers who purchase keyword advertising, at least in Britain after in Flora, than you would have in the United States. On those kind of issues where there was international disagreement, the idea of getting a substantive international law, which ICANN could essentially enforce, was going to be problematic. So if you're going to have that type of mechanism, it has to be on very narrow substantive grounds. Cybersquatting was one. Many of the disputes that we've been talking about, I don't think we could probably get that type of agreement.
So, question at the back. Yes.
See if I can do this technologically. This is also for Professor Kerr. I was intrigued by your comment that you thought that copyright was a more serious problem than trademark. And I was wondering if you had taken into account the economic waste caused by consumers having to, if consumers can't trust Poland Spring on a bottle, then all of us in this room have to spend a lot more time and energy looking at the source, whereas with copyright, the consumer is actually getting what they think they're getting. They're getting the movie, they're getting the book, whatever. The owner, the creator, is losing the profits that they're entitled to, and that would have some impact on their willingness to create. But you have that issue with regard to trademarks as well. But with trademarks, you also have the issue that if it gets to the point where consumers do not trust a trademark, leaving aside the perhaps impracticality of stopping trademarks, infringing goods at the border, if consumers can't rely on the name on the label, whether it's handbags or brake pads or something else, that there really is a much greater cost to society.
Well, thank you. Actually, it was a suggestion that I myself put in question. I had a question mark, I think, on the slide. And you were absolutely perfectly right. What I was meaning to say was actually that maybe what is going on the internet has a little bit, it has not this direct impact as in copyright, where you really get the things directly from the internet, whereas it's more complex in trademark law. Otherwise, of course, the damages that are caused to society and also to consumers may be just as high or even higher in trademark law. But I have to add that there is, of course, a lot of diversity of opinions also with regard to that, because very often you say that consumers don't trust the trademark, but of course everybody knows that consumers also with regard to trademarks get very often what they want, namely that they sometimes want the fake thing simply in order to be able to display the nice Rolex watch on their wrist, and so it's not so easy. It's sometimes they are really fooled. They don't know that it's fake, and they pay a price that the things are not worth. Sometimes they know exactly what is going on, and they still buy.
Did you want to answer?
So I guess I completely agree with Annetta. My feeling about the counterfeit situation is that there's a scholarly literature right now calling into question really whether we ought to protect against counterfeiting at all, given the fact that consumers so often know what they're getting, and theories of post-sale confusion don't really make a lot of sense. I think that in many ways the legal protection against counterfeiting is overbroad in order to protect the core of people who actually would be confused. I think the Rosetta Stone case does involve consumers who erroneously purchased the counterfeit stuff thinking they were getting the original. So there are many circumstances in which counterfeiting does result in consumer deception, and it's really hard to define a line on the spectrum between those cases and the consumers who know what they're getting, where we say this kind of counterfeiting is okay and this kind of counterfeiting is not. In my view, the courts and Congress see little social value in the counterfeiting, that they know what they're getting form of counterfeiting, and therefore they say, we don't really need to protect either those sellers or those consumers. So it's a kind of balancing of social value in which the courts say there's clearly no social value in the harmful form, and we don't think there's enough social value in the non-harmful form to differentiate it.
Right. Susy, can I just add one thing?
Yeah.
One thing, just to agree with Stacey there, but add one further thing, which is the line between where is the sort of they know what they're getting counterfeit and they're truly deceived. I think alters in the online context because very often the reason why people make the argument in the offline context, if you really are paying $10 on Canal Street and they're at the middle of the street and they're out of a suitcase, you probably know what you're getting, and therefore you do get what you expect. Whereas, in fact, that's harder to assess relatively, not always, but relatively in the online context. So it may well be that the debate that's going on in the offline context about post-sale confusion, which is an interesting debate, I think where you would draw that line might actually be different in an offline context and strangely more protective than you would in the offline.
And do feel free to raise your hand. I have a reasonably good visual memory and might remember who you are.
My question is to Linwood and Ed Court. The other day, last month, the European Court of Human Rights settled the Delphi against Estonia, which found the intermediary liability liable for the defamation messages that it was on the internet news site. This website had filtering, notice and takedown, it did everything, but the European Court of Human Rights said that it wasn't enough. So my question is, to what extent this resolution could influence two national European courts, even though it has nothing to do with the European Union, but some members of the European state, like Spain, is on the European Court of Human Rights, would influence, because he has talked about the Article 14 of the European Thank you.
Well, and I might want to answer some of this as well, but my first thought is what you raise is actually a very interesting, more general question, is the extent to which the European Union and the European Court of Justice in enforcing European Union law should have regard to what goes on in Strasbourg at the European Court of Human Rights. And historically, they've peaked at what's going on, but they haven't always acknowledged they're going to follow for a variety of sort of understandable institutional reasons. Indeed, I think probably they don't learn enough from the Strasbourg jurisprudence. One of the interesting things that happened, of course, since the Treaty of Lisbon is that the European Union is now committed, as a matter of the fundamental principles of European Union law, to comply with human rights jurisprudence. And one of the developments that we're likely to see is, I think, an increasing reference to that jurisprudence in the Court of Justice's case law, and certainly at least in the way that questions are being framed on reference to the Court of Justice. I think there's been a several-fold increase in the number of references to the human rights instruments. So I can't predict right now, based upon the past experience, how much weight they would give that, other than to say I think you're going to find more weight given to Strasbourg decisions than you did in the past. And it's interesting in the context of the two copyright decisions, the two SEBAM decisions under Article 8.3 of the Information Society Directive, there was a lot of discussion of the competing human rights claims. And in fact, in the Newsbin case in the United Kingdom, Mr. Justice Arnold weighed many, many different human rights provisions before deciding that he was going to issue an order against the internet service provider. But in fact, the interesting debate that was going on in the SEBAM cases, and to some extent at the National Court, has been criticized by some scholars as focusing on the freedom to do business and the right to protect intellectual property in Article 17, which is sort of absolutely stated, without thinking about the interests of the users, of third parties, whose speech rights may be adversely affected one way or the other. And there are cases, as a case on reference now, in fact, from Germany, I think, to the Court of Justice on the extent to which privacy interests of users should be taken into account in drafting the measure. So I think what you raise is all part of a broader picture, which is that you're going to see a much more complex set of constitutional balancing done by the Court of Justice, probably more like a French or German court than a British court, to be honest, in the future as they sort of work out the different parameters. And some of that has to be not just looking at the provisions themselves, but looking at how the Strasbourg court has interpreted them. And that'll be a big change from what's, I think, gone in the past.
I have to confess that I'm not familiar with that particular case. I would be interested in getting the reference. But what the court in Strasbourg does is, well, not decide cases. So they're probably not the ones saying, okay, this guy is liable in spite of what he did. What they probably have said is, well, the fact that the law, in that case, obviously the Estonian law, demands more, is not a violation of the right in Article 14. Which does not mean that, and of course when you talk about a violation of fundamental rights, usually this is found when there is really a gross sort of violation. And obviously the Strasbourg Court has been very cautious here, more cautious than they have been in previous cases when they have found violations of fundamental rights. We have this experience in Germany with the right to privacy of Princess Caroline. There they were quite ready to find that there was indeed a violation. Obviously, they were not ready in that case. But that still does not necessarily say that the Court of Justice, the European Court of Justice, the CJEU, and the other national courts have to follow the same. So it has not really a prescriptive value in that regard. But you're certainly right, and also Graham is absolutely right, that this may have some sort of influence in the sense that there can be more stricter obligations than what seems to follow from the decisions that we have seen so far.
Jane.
I'd like to pick up from where Edouard...
You're red rather than green.
I have the light is on, but it's not working. It's working.
Oh, okay.
Is it working?
Yes.
Okay.
So red means on? Okay.
Yes.
International confusion if there ever was.
Right. Where you are, it's green is on, and where we are, it's red is on. So we need a choice of rule. So picking up from Edouard, this is for Rochelle, Annetta, and Graham, and Edouard. And a little background for those of you who are not private international law geeks. Edouard referred to two projects, one of the American Law Institute and the other of the Max Planck Institute, addressing or trying to address the problem that Edouard started out with, which is the economic activity is global as a result of the internet when we're talking about trademark and copyright, and to a lesser extent patents. But the legal regimes are local, both with respect to the substantive law and with respect to which courts are competent to hear infringement claims. This is a symposium on secondary liability for trademark. And there is some difference of opinion between the Max Planck project and the American Law Institute project about whether there should be a different rule for secondary liability as opposed to primary liability, as well explained. And he also pointed out that this morning's discussion was pretty strong evidence that maybe the distinction between primary and secondary liability is not so clear. And this was very clear from Stacy's exposition of the American situation, where we seem to be collapsing primary liability and secondary liability. So Rochelle is one of the reporters for the American Law Institute project. Annetta is the leading reporter for the Max Planck project, although was also a participant in the American Law Institute project, and Graham was on both. So I'm kind of curious, in light of this morning's discussion, what do you think about the advisability of trying to have a separate choice of law rule, or for that matter, a separate choice of jurisdiction rule, when it comes to primary as opposed to secondary infringement?
So we'll begin at the end.
Okay. See, I have green.
Excellent. You may go.
So, the choice of law rule is one. Well, I mean, the fact that some countries have them lead into one another doesn't mean that that's the right way to do it. I think a pretty strong case can be made that there are differences. Sometimes, a actor on the international stage can be guilty of both. So you have to think about both. But I do think that conceptually there is a difference between them, and it's a difference that perhaps can be exploited. When you named the three of us, I thought you were asking the three of us because we wrote an article together in which we also suggested the possibility that maybe we need a substantive law rule to deal with the most egregious cases. So Graham before mentioned in response to the question about ICANN that sometimes you can agree on some things, and where we all can agree on something, maybe a substantive rule would deal with that problem. such as, for example, the egregious kind of counterfeiting, and then we still have some problems. But I do see a difference between them. I think that part of the conflation of them has also produced difficult questions about who has to be joined in the lawsuit, which I think can be dealt with in part by being a little more crisp and making the distinction.
Anita.
Yeah, well, before we made this suggestion, we had, of course, a very intense debate in the group about, all the difficulties that our suggestion would bring forth.
This is which group?
The Three of Us group. The Three of Us group first. It was then taken over into Clip was building, of course, exactly on what we did together in the article that we wrote. And I must say that also the arguments that Edouard brought forward, they are, of course, perfectly valid arguments, but we had them before and we have considered them, and we found that they were not really taking away the validity of our suggestion. As Graham said, well, of course, you can switch between calling something direct or indirect liability. Terminology is one thing. But even if that is a problem, there is a possibility, and Graham tried to do it in the beginning of his talk, to at least draw a dividing line between those who do who are, so to speak, on the forefront of what is happening. They are the ones placing content online. They are the ones offering the infringing product, and then there are others whose services are used. Whether you call them even direct infringers doesn't really matter. You can distinguish between the two forms of what they are doing, and our suggestion was that you look at what they are actually doing, and then you devise the rule concerning the applicable law according to what is actually going on, and not concerning and not regarding the terminology that may be used.
Graham and then Edouard.
As you know, Jen, I'm more probably favouring sort of worldwide solutions through choice of law than others. I think the answer to that, to some extent, is that there are a variety of different moving variables that, in order to achieve a worldwide solution that is acceptable and isn't regarded as extrusion of the single policy choices of one country to a global stage, you have to have substantive rules for where you can, because I think the efficiencies of that are worth pursuing. I think you have to give due respect for characterization issues, as Rob talked about, by the forum. I think you have to have choice of law analysis that doesn't necessarily dictate, and this, a few people agree with me on this, but I'll repeat it, that doesn't necessarily dictate a single nation state as the applicable law, and the court should have flexibility to modify and create substantive rules that might not necessarily correlate with a single state's rule. And I think you have to have an approach to recognition that an enforcement of judgments that gives deference to the process through which the rendering court actually made its decision. And it's a mix of all those different variables. Although I would tend, to get back to your starting question, I would tend towards being more comfortable probably than most with the single rule, and I would be more comfortable with a detachment, unlike Edouard, of the primary liability with the secondary liability, as long as there was a real substantive characterization process going on. And the reason I suggested at the beginning, which is when you're talking about secondary liability, particularly in the online environment, you're putting into play, and I think this is entirely consistent with the article that Rochelle and Annette and I wrote, you're putting into play a series of relevant policy connecting factors that might be different from the policy factors that are connecting factors that are relevant as a matter of policy of primary liability, which you bring into play sort of effects on technological innovation. So it's a complicated answer saying that I would certainly be more comfortable in detaching and find a single law, but it might be too easy and too simplistic just to say that's the only policy lever that one would have to push to make it acceptable on a worldwide basis.
So Edouard is just going to respond in a minute, but just before he does, I wanted to put Du Jing on notice that after Edouard, I'm going to ask her to address this question. So Graham has told us, and those of you who know me know I'll deliberately take this provocation, that he's interested in an international perspective. So we need to go beyond the transatlantic, because there's a few other choices of law out there, even if the transatlantic is somewhat successful in driving the debate so far, because I suspect there's a possibility that China is not interested in choosing any version of an EU law or a US law. So my question is there perhaps a perspective as to what choice of law rule might be applicable here that you could bring us from another perspective? But I give you at least however long Edouard speaks to contemplate this.
Now, from my point of view, it's clear that a specific choice of law seems very attractive and seems a good solution for those intermediaries. But at the end, I think that the outcome might be dangerous and may undermine IP policy, and more than IP policy, may undermine local policy. And in fact, I would raise a question. I'm not very clear as to the scope of law, as to the scope of those specific choice of law. This specific choice of law will be only applicable to the liability of the service provider, or would it be also applicable to the main infringement? No. Not to the main infringement. So the unpredictability will still be there. You see what I mean? So if you, it's a good idea, but if you want to offer a real predictability, we need too much. We need more, and more is too much. It's why I feel a little. You see what?
I think no, because the service provider, the platform, has a predictability problem because the platform is acting everywhere. But that doesn't necessarily mean that the primary infringers have a predictability problem. They know where they're acting from. They know where they're shipping the goods from. So the predictability issue is an issue that only comes up for the people who are, what I like to call secondarily liable, despite what Jane says. And that's why dividing it is actually helpful. Because for some of the people, you really do need to push for greater international cooperation, which has sovereignty problems, it has policy problems, but it has a payoff in terms of actually allowing people to develop their business models, price their services, and know how to act online. That same payoff doesn't apply for the primary infringers who are sitting, in Poland, sending out New York Polish spring water or whatever. They know where they're acting from, and they know where they're sending to. So I don't think that there's no payoff to having a great international agreement in that if, in fact, we disagree about what their liability should be.
Okay, I would like to respond from two respects. The first one is actually the issue Professor Disberg just put forward. We also debated a lot about it in China because, as I have mentioned in my talk, actually in the beginning the Chinese court approached the issue of secondary liability for trademark on online infringement from the duty of the ISPs, and they don't look at the fault of the ISP. You just see, no, you might have the duty of care to inspect the conduct of the online users. So that actually is a direct infringement, not secondary liability. Some scholars argue that we don't need the concept of contributory or secondary liability, and we can handle all the issues by using the joint infringement doctrine. So that's why some scholars think it's kind of direct infringement, not secondary infringement. So it's still a big debate in China even now. As to what China is doing now, I think mostly you can see they are following the United States rule. They favor the concept of contributory liability rule, like a safe harbor rule, and the as I have mentioned in my talk, impose a very limited duty of care on ISPs. They look more at the knowledge of the ISPs, and I think it's pretty close to U.S. Situation than the European situation, if I understand correctly.
Yeah.
Thank you.
Thank you. So I just wanted to, following some of those points, pick up on one point, and I think Rochelle sort of mentioned the business model and people having an element of predictability so that they can deal with that particular model. And I wanted to sort of just perhaps ask everyone to respond, because I see no hands waving, so I thought I'd ask a question. To the idea, so when some of this debate first began in copyright and is now looking more in trademarks, which is actually quite a common phenomenon with across border issues. So in parallel importing, where that is allowed, it often begins with copyright, and then people think, hold on, these copyright things involve trademarks or trademarks and so on. So that's often a method. But my question really goes a little bit towards this. So when you're thinking about ISP, immunity, safe harbour, liability rules and so on, much of the policy drivers behind that was to talk about the roles and functions of those intermediaries and how they needed immunity in order to be undertaking various tasks such as making the internet work or free flow of information or whatever your view is. So when we move to secondary liability, and much of what's been talked about quite rightly is looking at the doctrinal law approaches and whether or not there are different labels on those approaches. And the question which we've looked at from a few different angles, and I think that Edouard mentioned it specifically in choice of law, is who benefits from these rules, because it's unclear to me what if we're looking internationally, as to what the policy driver is. So there's the possibility that the very large ISPs benefit, but they're no longer. So if we go back and we think 20 years ago, we said, oh, they're managing the internet and so on and so forth. But that's no longer just what they do, right? They provide content, they control content and so on. So if we create the secondary liability regime, who is the beneficiary and what's the policy behind creating one or other rule? So a broad question inviting any or all of you to respond.
So I may have been too generous in conceding that we have moved into a world where both secondary and primary liability or direct infringement liability exists. I think the labels are both being used these days in at least some American courts. But I think that the version of, quote, direct infringement liability that we have going forward needs, as I said before, to kind of keep in mind the goals of preserving these intermediaries for their non-infringing as well as their infringing uses. I know that was not an answer to your question, but I will try to get to your question now. I think as we shape these rules, both for the big guys and for the small guys, we have to keep an eye on the balance, right, that has always been sought in these intermediary liability or indirect liability cases, right? We want to encourage parties to behave responsibly to the extent that they are benefiting from infringement and could easily and cheaply take actions to reduce that infringement. It strikes me that ought to be taken into account in the analysis. But I think we also can't lose sight of the flip side of the equation. They are facilitating, I think in most of these cases, all sorts of really legitimate behavior. And even the use of trademarks in the text of advertisements online can facilitate all sorts of wonderful legitimate behavior, including comparative advertising, including advertising of resold devices and goods. And so I think the danger of a non-contextual or wooden approach in one direction or the other right, is that you lose sight of the details, right, in the balance on both sides of the equation. I think there's room on the contributory infringement side to take a little bit more into account whether there were reasonable measures that could have been taken, right, by the intermediary. And on the flip side, in the direct infringement context, I want to make sure that courts take into account the desirable applications of this technology and make sure that those are protected and not threatened by the liability rules that are adopted.
I think that's really a very interesting and pertinent question. It's so interesting because the big mantra today in the economic crisis is innovation. We need more innovation in order to get our economies going. Now, both sides provide innovation. IP is definitely a driver of innovation, of course, in patents in particular, but also the other rights. They profit from the general idea, assumption of policymakers that IP is good for innovation and more IP is better for innovation and so on. That's one side. The other side is that allowing the actors in e-commerce, those who provide new models, to act out their ideas is also good for innovation. And these two types of innovation, they get clashing. In the European Union, it can these two types of thinking can be allocated to different general directorates general. So within the Commission, there is a sort of clash in that regard. One is emphasizing the need to protect IP as much as possible. The other side is protecting, is emphasizing the need to have a better possibility for those who provide services on the internet to do exactly what they want. And the Court of Justice, you can see, they are sort of torn between the two poles, and this is why the decisions that they render are sometimes a little bit erratic. It depends on, which judge is more in one fraction or the other, which makes it very difficult to get to a very consistent policy. Of course, the ideal thing should be to balance. But we have been talking so much about balance in IP that people can't hear it anymore. So when somebody said, the B word, we don't pronounce it anymore. So I think it's obvious, but how to achieve it in this climate of having these two antagonistic goals, bringing them together is really the art of, policy, lawmaking, or whatever.
So Graham.
Yeah, just a brief to follow entirely. I won't mention the B word. I was going to. I should have written down here, but I won't mention it. Because not to be too idealistic, but we should all benefit, I guess, Susy, and that depends on reaching whatever it is Annette was talking about there, between all the competing interests. And I would entirely agree with that. That depends who actually does benefit. Does depend not only on the substantive content of the rule that we adopt, but actually, I think to some extent, let me precede that question, the process through which we work out what that rule should be. And it seems to me, and this picks up some of the scholarship the AFIT has done, is whether you get there in a better way through a legislative process that's domesticated, whether you get there through an international cooperative process, whether you get there through private ordering, through things like memorandum of understanding that with large brand owners speaking to large ISPs, which is largely but not entirely what went on, whether you get there better through court proceedings to which everyone has access in theory, but the costs may affect, whether you get it through a public choice concern of people testifying and doing deals in a particular Congress. So I think, in fact, the process by which we get to that appropriate balance, to that particular substantive rule, is very important. And in Europe, it's not just even at the Directorate General level within the Commission. Because of new standing rules before the Court of Justice, and this makes it even worse. Even assuming the Commission can agree with itself and come with a particular conclusion, OHIM now has standing. And OHIM now, of course, has not just trademarks, because observatory is everything, has standing to appear before the Court of Justice, and there are recent trademark cases where OHIM took one position before the Court of Justice, and the Commission, having got its heads together with one position, took a different position. So I think, in fact, looking at the process by which we get to that best result is sometimes as important as what you might think ultimately at the end of the day should be the substantive rule.
So I see in the last minutes at least two people now want to put up
Susy.
their... excellent. We will have a comment from you.
Very short comment. I totally agree with Stacy. Balance is the most important term. In China, some courts pointed out that, like Edwards is a kind of innovation technology, but the innovation technology is no excuse for them to escape the liability for trademark infringement. In under specific circumstances, the courts have decided whether it's equitable to impose or to set up a higher standard of duty of care. So I think to sum up, the balance is most important. Thanks.
So thank you. So my job is to make sure we finish on time, and we're almost on time for lunch. So for those two people who did put up your hand, there will be time for you to have Q&A later, I am sure. So please join me in thanking the panels and speakers.